lawyers, non-lawyers, and other activists. Mr. Verma has been contacted me for the last 1 week to come here. I was stuck up in Hyderabad for the last 2 weeks. If you read newspapers, you would be knowing what is happening in Hyderabad. So I was not 100% sure whether I will be able to come here or not. But he still hoped, and luckily I am before you. The topic which is notified is closing arguments of the defense. It's all right. Now, I have some experience of trials, but mainly I'm an appellate lawyer. And in the apex court, I had the privilege of sharing very good moments with Dr. Justice Muralidhar for many years. But I have experience of trials, but they are generally very sensational trials, and the people involved are very high profile. I'll give you one example, and then I'll come to the subject. There was a very prominent member of Legislative Assembly in Uttar Pradesh, Raghuraj Pratap Singh. Yes, Rajavaiya. And he was supporting the then government, but something happened and he withdrew the support. So to fix him, I'm speaking very frankly with you, the police planted an AK-47 rifle in his house and made him into a terrorist. While he was being tried, some people felt that in Uttar Pradesh he will not be convicted. So they complained to the apex court and his trial was shifted to Madhya Pradesh. And almost every weekend for about 6 months I had to fly for the trial, come back. Ultimately he was acquitted, and he became the minister at that time of the same department which he had left. And today he is Minister for Jails, and I find that he is very competent to hold that post because he spent a lot of time in jail at that time. So he will know really what happens in prisons. And I believe many of you are interacting with prisons, either in the form of defending people or meeting people. So you also have first-hand experience of what happens inside the prisons, particularly when prisoners tell you what happens there. So the other trial experiences I have is 2G trial is going on. I was defending the minister. In Andhra Pradesh, the ex-chief minister's son, whose name you read every day in newspaper, is also today, what should we call it, in custody. And every day you must be seeing his photographs in the newspaper. So I have been involved in some trials as a young person, but later on I was mainly an appellate lawyer and not much in the High Court, straight in the Supreme Court. I go to High Courts other than Delhi High Court because I hardly have any context. Recently I did a very sensational case from Delhi High Court. If you have heard his name, Mr. I think R.K. Sharma, DGP Prisons of Haryana, who was convicted for life sentence for entering into a conspiracy to get a journalist killed. He was convicted by the trial courts in Karkaduma, Shivani Bhatnagar. And I had the opportunity to argue that appeal in Delhi High Court, which went on for nearly 3 months. And finally, case of circumstantial evidence and electronic record, telephone record. But he got acquitted. So I have very limited experience of trials, but mainly my experience is examining the trial record after convictions. And then I get an overview of what happened, what should not have happened, what mistakes were committed. And since the topic is closing arguments of the defense, now this comes at a stage, any trial on the criminal side would start with the FIR. That's the first thing which happens. And that's a very vital document. Sometimes people take a lot of consultations to get the FIRs registered, whom to include, what witnesses to include. A lot of things happen before an FIR gets registered. I'm speaking very broadly. And it ends with 313 statement of the accused and his defense evidence, if any. Normally people don't lead defense evidence or don't examine themselves as witnesses, accused. But after all that is over, you reach the stage of final arguments. And that's a very crucial stage, because whatever evidence has come on the file, what we call the judicial record, that is the only material you can consider. There is only one exception after the trial is over and judgment is passed. If appeal goes to High Court, there can be in some cases scope for further evidence under Section 391. That's all. Otherwise, whatever evidence has been laid on the judicial file, even the answers to questions put to you can be very, very vital. A wrong answer can land you in a lot of difficulties. Many people don't pay attention to answers under 313. People don't even care. I don't know kind of answers are given. It is my belief, and it has worked for me, whenever I read a trial file, because people come to me after conviction, the only document I call for is 313 statement. And I'll give you the reason for that. And that is what my senior, one of the seniors used to do. If you read the 313 statement of any case, you will get the whole case in 4, 5, 10 pages. Some 313 statements will run into hundreds of questions, sometimes even thousands of questions, depending on the complexity. But if you want to avoid reading the whole file, ask for 313 statement, read it from A to Z. You will get the whole case. Normally, clients will tell you we don't have it, because the lawyer at the trial court never bothered to collect it. Nobody pays much importance to 313. But a wrong answer in a circumstantial evidence case is usable against the accused, because false answer also becomes a circumstance against him. That's very important to understand. So when you are arguing at the end of the case, as the subject says, you start with the FIR, then 173 report, very important. What police has done. Thereafter, charge. People also don't care much about charge. Very important document. Because evidence can be laid only on the charge as framed, nothing beyond that. And thereafter starts examination of witnesses, comes to 313, and defense. Now, when you are concluding the arguments, arguing at the end of the trial, you should be familiar with all these parts on your tips. Because you are presenting to the judge the whole case at one go. Everything else is in parts, like, in films, they photograph reel by reel. In one scene, you will find 5:30. Immediately next, it will be 12, because there is a cut in between and nobody has bothered to adjust the clock. You will find so many examples. But here, the whole case must be in your mind here. That's the importance. What is the prosecution case, whether they have been able to establish it or not? What are the missing links? Whether you have filled them up by asking wrong questions, but the prosecutor forgot, you have asked that and filled up, which I call judicial harakiri. That the prosecutor forgets, you ask a wrong question and get an answer against you. Some brilliant lawyers are able to do that also. When you are asking questions, what is not to be asked is more important, because we are in the habit of speaking. Speaking less or not speaking is very difficult to restrain ourselves. Client is there, people are there, you go on asking question, and at the end you find what he never asked, the prosecutor, you have brought that out. And in the appellate court, judge will tell you, why did you ask this question? I have to say, sir, I was not there, but people are in the habit of committing suicide, I can't help it. I just can't help it. So this whole overview And then you are arguing something by looking at the judge face to face. Look at his eyes, look at his reactions. If he's not receiving something, don't push it. Thereafter, he'll stop listening. This is human nature. Don't torture anyone. I'm using a very loose word. Don't torture anyone. You will not say anything, but the order will go against you. So be highly sensitive of the judge, because it's not a machine we are speaking before that you stand up, put a coin, and the weight will come out. No. It's a very sensitive profession. In the Constitution of India, there is only one profession which is recognized by the constitution makers, legal practitioner. Go and check up Article 22. As soon as a man is arrested, people can be detained without arrest, everybody knows it. But if a man is shown arrested, first thing is you have to give him the grounds of arrest. It's a constitutional mandate. Where you people fit in, people don't get the chance. They have nobody to advise them. The second right is to consult a legal practitioner of your choice and be defended by him. And I'll tell you what choice means. Choice of a millionaire and choice of a rickshaw puller. Word is choice, but you know the difference. You know the difference. Choice is restricted by your surroundings, by your economic capacity. Everybody would like to be defended by a very competent person, but you can't afford, you can't reach. It is a good word in the Constitution, and that is where I think the legal aid comes in. And this movement has been going on. Dr. Muralidhar has written a beautiful thesis on that. He has worked hard towards those institutional legal services authorities. These are all new concepts. When I was young, this was a growing idea. Justice Krishna Iyer, Dr. Singhvi, they all used to work on these themes. And then we brought out these agencies which fill up the gap. A person who cannot afford, we give him help to make him equal. That's the idea. Nobody should be sentenced or punished without getting an equal playing field. State can organize good, competent prosecutors, but every accused cannot organize that. And that is where people who are sensitive, who feel that injustice should not happen, they come forward all over the world. And in certain countries, you have public defenders, which in India means legal aid. So you have highly organized public defender system outside. Very motivated persons, as strong as the prosecutor can be, so that the balance is kept equal. So when you are doing this job, because this is your last opportunity in the trial, concluding arguments. Thereafter, it will be conviction or acquittal. Generally, it is conviction. There are a few acquittals also. So once it is conviction, then whether you argued or not will be tested in appeal. If you raise a new point, any intelligent judge will ask you, show me from your arguments. Did you take this point? Was it available to you? Why did you keep quiet? Why did you not point out to the judge? Because you have to show from the record. Nobody can say, I argued it orally. It must be noticed by the judge. Written in the judgment itself, it is argued, it is argued, it is argued. Contra, this is argued, this is argued. So be very careful. When you are challenging the whole edifice of the prosecution, see their weak points. See the missing links. Where it is likely to fall. How will you get benefit of doubt? Reasonable doubt, not a fanciful doubt. Reasonable doubt. So there you have to convince a human being who is very experienced. Judges are highly experienced because they are devoted people. I may be doing one case at a time, but they'll be listening to at least a dozen cases at a time. Even trials are so many. It is like making a film. One day one witness, after 2 days another witness. If it is a routine trial, it goes on for years together, you know that. Highly sensitive trials may be day to day, but not many. Not many. So it is like he will hear one case, give a date, again hear that case. Sometimes the trial is over and you will have at least 6 or 7 judges who have handled that file over a period of 10 years. So when you are dealing with it, many judges will say, we'll decide it at the final arguments. This is admissible piece or not admissible piece, in bracket, to be decided at the final stage. Many trials you will find that statement. The lawyer will forget because even lawyers get changed. The judges get changed. Nobody notices that those pending questions are still on the file. They are never argued. No decision is given on that. Because everybody must go through the whole of evidence himself, whosoever the lawyer is, and to master the facts. My senior used to say, the first senior, you master the facts, the judge will find the law for you. Don't bother about the law. Law follows the facts. Good authorities means nothing unless the facts are in your favor. So convey the facts to the judge. His conscience will guide him to get you some relief or the other. If he's satisfied on circumstances, for example, I take a case of a person who is caught in a situation, he fires once, nobody bothers, one person dies. Again he is surrounded, he fires second time, nobody bothers, he also dies. Third time he runs on the roof, people are still after him, he fires 3 times. 3 persons die. Very cold-blooded murder. But when you present the circumstances to the judge, that either it was his life or their life, you have to balance it. You have given a right of self-defense to a person. He is not going to wait till the end. This person was an NSG commando. And later on he became a gunman of a bank. Now he had a licensed gun. The judge said in the High Court, why did he not use like a lathi and scare them from the butt side? I said, my lord, a trained commando. Just like that he fires, otherwise he is not fit to be a commando. He is a useless person. Now whenever he is facing a situation, a commando will react so fast that the person he is protecting is unharmed. So here his own life is in danger, he has to fire. But why did he fire second time? I said, look at the circumstances. On the road there are stones and stones and stones. Now what is to do? He is running, people are throwing stones at him. Second fire. He goes on his roof, they break his door. Third fire. Superficially, it's a case of death sentence. 3 murders, cold-blooded murders. High Court says, okay, we'll give you life. I convinced the Supreme Court this is a case which is not of cold-blooded murder, not of a planned murder, caught in the situation. So please give him a proper sentence. What is that? 7 to 10 years. Why give him life? So this is where your mastery of facts will come in. Study the record yourself, study the site plans yourself, study the recoveries yourself. Even at this age and this position, I go to the record room and see every paper myself, original paper. Because you will find cases, on the midnight the date changes. When they are antedating, they forget that the offense occurred before 12 o'clock. After 12, the date has changed. So they will go by habit in the new date. Offense has occurred in the previous date. What they will do is, they will do something on that Roznamcha and change the date. Now you can't get it in the cold print of cyclostyle papers or photostat papers or anything. This is a transcription. Go to the room, call for the record, take a magnifying glass and see if there is rubbing there. And in that investigation, the whole story of an FIR being, prompt, spontaneous, everything is finished. Because once you cross the line, you have still 12 hours on the next day. So all that hard work has to be done. The maximum hard work has to be done in the trial. Maximum hard work. And the concluding arguments are the masterpiece. The higher you go, you are paid more, you have to work less. Because by the time the record comes, everything is on the file. Except 391, further evidence. Once in a while it may happen. So people like me would sit on the record, study it at one go, whereas the trial court lawyer may have spent 2 years in building it up slowly, slowly, slowly. He has to go back 2 years, study the whole thing and argue at one go. We only see the file for one day and then argue from that file. That is the importance of concluding arguments. Nothing should be left to chance. If you can, make a summary of it. Assist the honorable judge by giving that summary so that it becomes part of the record. You have a right in the CRPC to put in written submissions. So don't leave anything to chance, because if you are dealing with serious cases of homicides, when you slip, the man will remember you for 14 years in custody. Every day he will say, Mr. Sushil Kumar argued for me, but I'm here, I'm here, I'm here. If he gets out, he'll forget me, but if he's inside, he'll remember me every morning. I know that for sure. And that is what you will feel when you visit the jails. People who are inside, who are not able to get released on bail, even as under trial, sometimes they spend more time than the punishment they could possibly have got. These are all recorded judgments of Supreme Court. And that is where the legal aid has helped a lot. And very, very conscientious judges, sensitive judges like Justice Bhagwati, Justice Krishna, and others have taken up the cause. Postcard can convert into a writ petition. Delhi jail, big inquiry was held. From Dr. Jain murder case, there was, I forget the name of the gentleman. He sent a complaint against the jail. This being very bad atmosphere. District judge was appointed to inquire into it. I'm talking of 70s. State appointed me to defend them. So I know more than what the other side knew. So you have to be very, very careful. And concluding arguments are the foundations of further work. If you win in appeal, trial, finished. State may challenge. Because some cases, state will not leave you. Today, the law is amended. Even the complainant can file an appeal. Equal right. The victim's parents, brother, or whatever is permitted category in the section, I think it is somewhere around 377. I forget the section, but I remember the essence. They have a right to challenge. State is sleeping, they will go in appeal. Again, the whole thing will have to be examined. So whatever foundations you people are leaving at the trial stage, that will go right up to Supreme Court. You can't change anything in that. Only perceptions and appreciations will change, not what is recorded in the trial court. So you have to be very responsible in that. Very responsible. When I have cases, I have sleepless nights, even at this age. Because if I slip, the man will stay there. We just can't get out. Well, my mistakes, nobody can catch because it will be so subtle. But I know that I have made a mistake. Everybody knows in his conscience where he slipped. So you have to be answerable to your conscience. There are no external checks once I am in Supreme Court. There is no court above that. Mistake is mistake, finished. Yes. We can't go there. If we go, we can't come back. So that is one-way ticket. So I am very brief in my presentation because I think Dr. Justice Muralidhar should also have a chance to supplement it. We have been together lecturing to Supreme Court lawyers at that time. He was very vocal in organizing. And I also believe there are training institutes for judges now. There are trainings for lawyers, but not regular. But this training program is very helpful because it sensitizes you. It makes you more responsible. Society which has given us so much in abundance to live well, we owe it back to the society. Most of the work people do is not paid in that sense. Very nominal. Because of your good people, you contribute. So everyone who can, and I tell you from my experience, the judge asked me 2 days back in the High Court, you are so expensive, why don't you help the poor? I said, sir, you come to my chamber, you'll know how I help. One person may give me 1 CR, the other person will give me only 10,000, but I think when I do both the cases together, it is divine justice. That person feels so gratified that I accepted his case. Whenever my talent can be used, I will not refuse it for money. If I have time, I am in session, I will do it. My attitude is not controlled by the money it is paid to me. It is controlled once whatever money I have charged. Once I have taken the case, then it is my case. I get into it like it is my personal case. So that sense of dedication has to be there. Hard work has to be there. And when you have hard work and you get an opportunity, that is the meeting point for destiny. We get opportunities, we are not ready to receive it. We are ready, but opportunity is not coming. But when both of them click at a point, that is your destiny. So each one of us makes his own destiny in this highly service-oriented profession. And I'm reminded of the old English times when he had a gown with a small pocket at the back. People after the case would come and drop something in it because people were very rich, noble, who could afford to live otherwise. This was just a service. Of course, today it is a profession, but sometimes the lines between profession and business get blurred. Sometimes it happens with some people. It's more for the purpose of self-enrichment rather than giving it back to society, but exceptional people. Generally, people like you who are gathered here, who want to learn, who want to serve better, who want to be sensitive about things, and you request us to come and share our experiences, and then you will ask questions, we'll give you more. I'll request Dr. Justice Muralidhar to supplement, and then we'll throw the floor open because I'm more of an answering person than making a speech myself. I get more excited in answering focused questions because you are people in the field. You will have the personal experience as to what should we do in this situation or that situation. So my words are almost over. One of my clients was accused of committing a double murder of two sisters. You can note down the name of the case, Ashish Batham versus State of Madhya Pradesh. I think it is 2007, but if you will punch Ashish Batham, it will come straight. Ashish Batham, Batham. Ashish is a very common name. Ashish Batham. Please read that case very carefully. It is a case only on circumstantial evidence. Yes. The trial court gave him death sentence for double murder. The High Court was kind enough to commute it to life. But his father, the retired deputy collector, said that my son is innocent and you have to prove it. I said, after two courts, it's very difficult. Every judge will say, you already got cheap. The sentence is not there, life is there. What is the problem? Anyway, with great difficulty, we had that case admitted. But when the appeal came, it was a case, according to prosecution, of friendly entry because the elder girl was in love with this boy. And allegation was that when the parents went for morning walk, he went inside the house, friendly because the elder girl was in love with him. So she opened the door. That's the prosecution case. He entered there. He caused about 17 injuries to the elder sister by knife. And also about 14 injuries to the younger girl. Or the numbers may be reversible. That's long back I argued. And then left from the house. Later on, the parents came and found both the girls dead. That is the allegation. Very brutal facts. So, as usual, I studied the case very carefully. A case of friendly entry. Friendly means this boy who was liaising with that girl for years together and had left the town. The parents were high caste, the boy was low caste. So maybe they refused the marriage on that ground, and in anger or revenge, he came and killed them. That's the story. Two courts believed. Death sentence given, commuted. I didn't want to take that case. Apparently very difficult case. And the person could not afford my services also, because I have to give up something to do this. But he would come to my house. I have a Shirdi Baba statue in my house. He would come and lie down in front of that statue and says, I will not leave your house till you say yes to my case. Very difficult to get out of the situation. I went and studied that record. I'm telling you how grossly mistakes can be made and people can get the sentence. I studied each and every paper. There was a blood report by the lab. But nobody noticed that the blood stains were on the roof. It's a case of friendly entry. You come from the front, you leave from the front. Now, I was bothered about how did the stains go on the roof. That was the only point I had in my favor. And both the courts ignored it because both the lawyers never studied that. Paper was lying very clean in the record. And I built up my whole case on that one single document. And if you will read that, I don't remember the details, that will give you all the answers. That the acquittal is based largely on that fact, that how could the blood go on the roof? But both the judges, means division bench in the High Court, trial court judge, missed it because nobody pointed out. Judges are not supposed to read the record in that sense. You have to point out, that's your duty. When you're defending a person on a death row, you will have sleepless nights. Telling you frankly, because if I miss, the man is gone. So, apart from other arguments which I made there, and luckily, and you have to study the benches also, sorry, because By experience, you know to what extent this honorable judge will go. Beyond that, he will not go. And when you have a combination of 2 and 3, then you have to sort of make an assessment whom to address more, even if he's a junior judge. You convince him, he'll convince the senior judge. He'll do your job. Like that. All that comes from a lot of years at the bar and their body languages. Some people touch the file. Mostly Supreme Court judges read and come. Maybe in the high courts also. So when they touch the file, instant responses come. I was doing Priyadarshini Mattu case, so sensational in Supreme Court. The whole case was a charge of rape and murder. In my view, the semen was planted by CBI to fix the boy. Because his father was a very senior police officer. From Delhi police it went to CBI and there are a lot of complications behind it. I don't want to share that with you. I morally convinced the judges that there is the chance of plant. Now, because the case was so sensational. You must be knowing in Delhi. Huh? Nobody would give me relief. In such a case when TV is blasting every day. Kashmiri Pandits, others, so many pressures. But I shook their conscience that there's a complete chance of planting here. They suo moto commuted to life. I never pleaded that. In death sentence, I hardly plead for sentence. I leave it to their conscience. But I shake their conscience so much. You read many of my cases in Supreme Court, arguments for sentence I will never make. I will make on merits, but I shake them so much that they can never confirm death sentence. I only argue one. My Lord, it is a case of acquittal. In any case, it is not a case of death sentence. This is my only argument at the end. So if you read Priyadarshini Mattu, if you read this Ashish Batham is classic case. After many years, Mr. Jethmalani had done a very powerful case of circumstantial evidence when somebody poisoned his wife. I forget that. Sharda Biddichan. After that case, this is the case. He, of course, is a great master, very elder to me. I get a lot of inspiration from him.
Sharad Birdichan Sarda.
That is a case on many propositions.
Birdichan.
Sharad Birdichan from Maharashtra. It's a case on many points. For example, if the judge fails to ask you a question in 313, putting that piece of evidence, finished. You can never use that piece of evidence, whether it is against you, for you, whatever. Whatever questions you have asked and answers have come, only that is what is usable. If some judge uses some other piece of evidence which is not in 313, barred, completely barred, not usable. So many times from legal propositions, you will get actual answers to your questions. You make a study whether this is put to the accused or not. That is why I said people don't read 313, they don't pay attention. Mechanical answers are given, I don't know, I don't know, I don't know. You are supposed to explain everything. The burden is on you. If you give good explanation, useful. Wrong and bad explanation, circumstance against you. The judge will use that and confirm the conviction, drawing corroboration from a wrong answer. So like that, Ashish Batham you read the Priyadarshini Mattu, pick up cases of circumstantial evidence. They are the most teaching cases. Witnesses can lie. They do lie unless you break them in cross-examination. But circumstances never lie, whether it is for the accused or against the accused. If you are able to explain circumstances against you, bound to get an acquittal, but what hard work you have to do. This single piece of paper, which nobody studied over a period of 5 years, lying packed in the record. I went there and found, I was shocked, that how did the blood stains go on the roof? Either the person must have left from the roof and the dripping knife may have put those blood stains on the roof. I did a case of firing on the roof. Evidence, profuse bleeding. Witnesses are lying. Profuse bleeding, not a drop of blood on the roof. All that hard work is in the papers. Forget the witnesses, first control the circumstances, the documents, and you will get lots of answers. The difficulty is we are not spending so many hours. I'm not saying that you should only spend that much time for which you are paid. It must be your passion. If you are in the field of justice, it's a divine function. He is called Lord because he is working on behalf of God. He can give a death sentence to somebody. He can decide for 20 years you will stay in this place and eat this food. He writes their destiny because it is transferred to him by God's grace. So he is the last word in certain areas. You become the last word in your areas. Leave nothing to chance. Please spend so much time on the record. You will get a lot of answers. And at the trial court stage is the real time. After that, except 391, everything is sealed. Nothing can be done again. Whatever has come, has come. So this is how I can inspire you. Spend time and time and time on your record. Practical side on the ground realities are different. I have also come from Tisazari courts, but that was maybe 4 decades back. And I have some idea of Patiala House, Parliament Street, or Karkaduma. I'm not even knowing there are other courts in Delhi also. But these problems are always there. Sensitivity of the judge. As I said, he's sitting over the destiny of people. It's not a job, not a salaried job, just like that. The attitudes have to be developed. They have to be equally sensitized. People at younger age are doing that. See? For example, every investigation is under the supervision of a magistrate by statute.
Things are improving.
Yeah, I'm coming to that. I'm coming. I'm not accepting fully the dark side, coming to that, but I'm a slow person. So it is said about me that if you want to have longer arguments, engage him because he'll go very slow. He doesn't rush through cases. I'm called a roadblock in some courts. So there are chances and opportunities to sensitize the junior most judiciary. For example, under 167, who is the first person who interacts with the accused? A raw magistrate. The whole of Article 20, 21, 22 is in his pen. People are supposed to see the case diary and then give remand or not give remand. No, you don't have to react. I know what happens in the trial courts. That is why I said I have come from Tisazari. Fortunately for me, the destiny kicked me up, that's all. Otherwise, I would still be sitting under that roof, what is that, police post roof, below that, mostly. I have come from there. I know the hard realities. When I went into the court first time, long back, my senior said, go and check up the date. The clerk said, you go to that room, check up the date. I went and stood before the person who has that big register of dates. I spoke to him, he would not look at me. No answer. Then the Munshiji came. He said, you just like went there? I said, yes. He will not answer. Keep a small red 2 rupee note here. Put it like this. The note will disappear and date will come out. It happens. The color of currency may have changed now from green to whatever. I have lived those days. But I took up a degree of Master of Jurisprudence from Delhi University. I'm the only one who did. After me, the course was abolished. It was introduced in 40s. I'm the only Peace Master of Jurisprudence, LLM, from Delhi University, and after me, the course was abolished. I said, if I have to do this, having studied all kind of jurisprudences of the world, taking a master's in jurisprudence is not easy. People joke with me, how will you use it? Today I find that it's much more useful to me because everything is in the background. Without jurisprudence, like Kelson's Grundnorm, we have nothing in system. So like that, things will improve. We have to be positive, understand. But then you must be strong enough to somehow get their attention, show your capabilities. People come around. I have dealt with most hostile judges in the beginning, and at the end, they are most friendly judges. Once they realize what you are worth, they'll respond. So the age factor at that time, the number of cases, Supreme Court, we may do one case for 1 week, but there the man has to dispose of 50 odd cases. See the cost list. See the pressure under which he works. So you have to look from all sides, and given those limitations, whatever best you can do for your client, you have to do. So don't be pessimistic about it. I know it is a very hard job. I know. I have gone through all that. I'm a first generation lawyer in my family. No support. Completely self-made. Completely, I can tell you. I could not make 500 rupees in a month at one time. And I can't tell you how the fraction of a second I make that much money. Fraction of a second. That is hard work only, nothing to back up. As you grow in your profession, people recognize your value goes up. Don't give up hope. I think you can convince those youngsters. I'm sorry, I'm using that word, youngsters in the sense of experience only. Otherwise, they are as good as any Supreme Court judge. The Supreme Court judge cannot give remand, he can give remand. And you know what happens in those 15 days of police remand? I don't have to tell you. The whole case can be made or unmade in those 15 days. Foundations, 164 statement, this confession, that confession, you know how the cases are built up? Pick up CBI cases, old time, all confessions only, no witnesses. All serious cases, one accused will make a confession in those first 15 days. And they will treat him in such a manner that he will not be able to stand up on the floor, but there will be no visible injury. I've seen all that in Tisazari. People are brought, they can't put their feet on the ground, but there is no injury. So all those hardships are there, and they have been every generation. Don't think that there was good time at any time, not a bad time now. Every time has its own adequacies, inadequacies. You have to get hold of opportunity and make it up. That is where human ingenuity comes. We are not computers that what is fed only will come out. Till now there is no artificial intelligence in computers. It's only what is fed inside will come out. But what is not fed in you can come out because God has given you a gift. If a brain was to be measured in terms of computer, the wiring will have to go around the cosmos so many times. Read the books on computers. This is the most powerful computer God has created, by which we even deny the Creator Himself, some of us who are atheists. They don't accept God. So please don't be disheartened. Keep doing your good work, good work, good work. It will bear fruits. At least I am sitting before you at an old age. I had all these frustrations in the beginning. I never gave up. Things happened. If they can happen to me, they can happen to you. So please, go on doing your best. Convince the judge. That is where the power comes of conviction. Please, don't give up.